I just want to, go ahead and get it started and hand it over to Larry Reicher. So Larry is the current chief of the Office of Decree and Enforcement Compliance in the Antitrust Division at the U.S. Department of Justice. And he is also an Emory alum. So Larry, go ahead, take it away.
Thank you, Colby. I appreciate the introduction. It's great to be back at Emory, even virtually. Before I get started, I need to give the disclaimer that most government attorneys need to give at the beginning of things like this. The views I'm expressing and the questions I'm asking today are mine and mine alone and don't represent any views or opinions of the Department of Justice or any of its representatives. So thank you, Colby, for organizing this, and to the full ELJ staff for their hard work. I also just want to give a thank you to Professor Arthur. My interest in antitrust started in his class about a dozen years ago, and Emory is lucky to have multiple alumni and leadership positions at the Antitrust Division, and that could not have happened without encouragement and scholarship, starting with the likes of Professor Arthur. And last but certainly not least, let me thank my mother for joining this program. I don't know if she's joining because she's excited to hear her son and thought maybe that her granddaughters might try to jump in there from behind and come down here in the basement, or if she's just after some CLE credit, but I appreciate her attendance. So now to the main event. Today's panel discussion, which is Antitrust and Big Tech, Consolidation and the Resulting Tension. It is, to put it mildly, a timely topic. Just today, Senator Klobuchar introduced a bill that would revamp substantive antitrust laws in ways not seen in decades, if not a century. So to tackle this mountain of a topic, ELJ has assembled a stellar panel with Professors Lau and Professor Alford. Before I introduce them each in turn, let me just remind our audience members that you can provide any questions in the Q&A tab in Zoom, and we will try to get to as many of those questions as possible at the end. So now, with no further ado, let me introduce our first panelist, Professor Marina Lau. Professor Lau is the Board of Visitors Research Scholar and Edward S. Hendrickson Professor of Law at Seton Hall University School of Law. From February 2015 to June 2016, she served as the Director of the Office of Policy Planning at the U.S. Federal Trade Commission. And she began her career as a trial attorney in the Antitrust Division of the United States Department of Justice. She has written, lectured, and commented extensively on antitrust law and policy. Professor Lau, the floor is yours.
Okay. Thank you for the kind introduction, Larry. And I'd like to thank Colby Moore and the Emory Law Journal for inviting me to participate on this panel. It's a pleasure to be on the program, if only virtually. Everyone seems to be talking about antitrust and big tech these days, right? In December, the FTC and 48 states filed separate complaints against Facebook, alleging primarily that Facebook's two acquisitions, Instagram in 2012 and WhatsApp in 2014, were part of an illegal strategy to monopolize personal social networking services. And just weeks before that, the Department of Justice Antitrust Division had filed a lawsuit against Google, also for alleged monopolization. And apart from these two high-profile cases, there's now growing popular backlash against the tech giants, with some critics going so far as to call for the restructuring of the large companies, that is, essentially breaking them up, as Senator Elizabeth Warren did last year. We could probably spend the whole day here debating the many important issues that just the Facebook and Google cases have raised. I'm obviously not going to try to do that. Instead, what I'm going to try to do is to focus my 10, 15 minutes on some of the most difficult merger enforcement issues involving acquisitions by big tech companies, which the FTC case against Facebook has indirectly highlighted. So very briefly, the FTC case against Facebook centers on its Instagram and WhatsApp acquisitions, with the FTC alleging that those two acquisitions were part of a strategy on the part of Facebook to foreclose competition in the social networking market and to maintain its dominance in that market. And the FTC is seeking as a remedy the divestiture of those two apps, Instagram and WhatsApp. That is seeking an unwinding of the acquisitions. So what the complaint conveniently leaves out is that the FTC had previously cleared both acquisitions without any conditions, right? So in other words, the FTC is evidently believes that the acquisitions should not have been cleared in the first place, right? At that time. By the way, in addition to Facebook's acquisitions of Instagram and WhatsApp, the five tech giants, Google, Facebook, Apple, Amazon, and Microsoft, in the aggregate, managed to make over 500 acquisitions in the past 10 to 15 years, most without any antitrust challenge from either the DOJ or the FTC, or from the European Commission for that matter, the European Commission competition authorities for that matter, or at most with only a few conditions attached. Since the merger clearances were given during a period of unparalleled growth in the tech sector, when the agencies were on notice that vigilance was promptly called for, a few related issues or a few related questions naturally pop up, right? And that is, are our enforcement agencies sufficiently strict in enforcing the merger laws? And is our merger law up to the task of dealing with big firm acquisitions? If not, why not? And what changes might be called for? And that's what I'm going to try to talk about in my allotted time. I think to start out with, I should reveal my own personal bias. I think that merger enforcement in this country overall has been too lax for the past 2 decades or so, particularly in the case of proposed acquisitions by the large technology giants, and that we should err on the side of prohibiting acquisitions by these large tech firms when in doubt. Now, given I believe that our merger enforcement is not sufficiently aggressive, a logical question to ask is whether the antitrust laws that we have are up to the task. First of all, I don't think that the merger statute itself is the problem. Section 7 of the Clayton Act is very broadly written. It prohibits mergers whose effect may be to substantially lessen competition or tend to create a monopoly, right? So the language itself is very open textured and is flexible enough to do the job in today's digital markets. The statutory language itself doesn't preclude the FTC, for example, from showing that the Instagram or the WhatsApp acquisitions should have been prohibited on the theory that the acquisitions would foreclose potential competition. But much of antitrust law depends on case law development, and it revolves around the analytical framework that's been developed and on the government's own merger guidelines. And together, these have made it very difficult to prove a Section 7 case in general and for tech acquisitions in particular. So as everyone in the antitrust community knows, but I know that this audience includes some people who are not really in doing antitrust work, so I just want to talk a little bit about it. In most countries, including the US, whether a merger is considered anti-competitive doesn't turn on the size of either company. Rather, it depends on whether the merger may substantially reduce competition in a properly defined market. So the standard analytical framework for evaluating mergers typically involves defining the market and showing the probable adverse effects of the proposed merger in that defined market. Now, I think everyone knows that market definition is very challenging. It's a very challenging exercise, even in traditional industrial markets. But at least in those markets, the analysis works quite well, right? It can help us determine if widgets and gidgets, for example, are reasonable substitutes. And that's useful because if they're not reasonable substitutes, that is, if they're not in the same relevant market, then even the merger of the dominant widget producer and the dominant gidget producer would have minimal impact on either market, and they wouldn't be cause for antitrust concern. But this approach and the economic tools that are used work best for firms that compete mainly on price. It doesn't work well. We could even say that it works poorly with markets where technology developments are key and firms compete mostly on quality and, more importantly, on innovation and not on price. So for instance, if you apply the traditional framework to the WhatsApp acquisition, the assessment would probably go something like this. Now, by the way, when the FTC closes a merger, closes a review, it doesn't give the reasons. And so what I'm doing is I'm just looking back, and except for very, very high profile cases. And so I'm just looking at it, and I'm saying that probably this is how the assessment would have gone. They'll say on the consumer-facing side, Facebook is primarily a social networking service, and WhatsApp is a digital messaging service like iMessage. Facebook and WhatsApp didn't overlap much. In any event, the digital messaging market was quite competitive at that time. There were a number of digital messaging products, including iMessage for the Apple products. Therefore, the merger can't be shown to substantially lessen competition in the consumer-facing relevant market. Now, on the advertising side, on the digital advertising side, the analysis would probably have gone like this. The targeted advertising market was quite competitive in the sense that there were, and there still are, a number of actual and potential competitors who are equally placed as Facebook to offer advertisers targeted advertising. And so probably the anti-competitive effects can't be demonstrated on the advertising side either, right? So to the extent that the FTC felt it had to hew strictly to the merger guidelines and to the traditional analytical framework, their given clearance to the acquisition can't really be faulted. At least it was understandable. Incidentally, and I'm not sure that everyone knows that, the European Commission, which generally has a reputation of being much stricter, taking a much stricter approach to merger control than the US, also approved the acquisition and without any conditions. And yet, something told us even then that the approach of this framework probably didn't fully capture the acquisition's comparative implications. It's hard to believe, for instance, that Facebook would have paid $19 billion for what was then a small messaging platform with just 200 million users and only 30 employees at the time, simply for the sake of buying a messaging platform, right? Doesn't quite make sense. But the analysis that we use, the tools that we have, simply doesn't help us answer the important question of what the firm was being bought for. And so it's hard to determine the comparative effect. Now, with hindsight, when we have access to some of the facts and so forth, we sort of have a better understanding. So in my view, one of the problems with our current approach is that it's become too rigid for today's digital economy. And it's become too reliant on quantifiable evidence and objective measures, such as the HHI, the Herfindahl-Hirschman Index. Now, the move to this scientific process, if you will, was well-intentioned and was probably a reaction to the cases in the 1960s and early 1970s that are now seen as not being sufficiently rigorous in this analysis. But the problem, though, is that the fine-tuned approach that we now take, such as the SNP test for market definition, the sophisticated HHI for measuring concentration, and so forth, are quite good in identifying mergers that are likely to lead to higher prices or reduced output in a defined market within a relatively short term. That is, our approach is pretty effective in helping us predict whether a merger between two of the three national baby food producers will likely lead to higher prices, which is the Heinz case, right? Or whether it does a pretty good job in telling us whether a merger between two of the three national office supply superstores would likely lead to higher prices for consumers. And that's the first Office Depot case. But it's not as good in evaluating whether an acquisition is likely to reduce innovation in the long term and what is overall economic impact might be. So, so the question is, what can be done or what should be done about it to correct the situation, assuming that you agree with me that our approach is probably not working as well as it should. So I think one approach, and I'm not saying that this is my preferred approach, I think one approach would be to adopt a blanket presumption against acquisitions by firms above a certain value threshold, and then shift the burden to the merging firms to rebut the presumption. Okay, so we could conceivably set the value threshold high enough that only a finite number of very large firms, including all the large digital firms, would, but only that small number of firms would be subject to the presumption. And my argument for having this presumption would be that the firms proposing to merge have a far better understanding of their circumstances, the technologies, and the big picture in their own markets, in markets in a broad sense. And therefore, they are in the best position to show that the merger will not be comparatively harmful along dimensions that otherwise would be very hard for the government to measure and to prove. So in essence, this approach would require the acquiring firm in particular to lay out its motivation for the acquisition and to articulate what it is, what its long-term plans are post-merger. So the idea is that with their superior knowledge relative to the government, they are in a better position to make their case for the merger than for the government to make the case against the merger. And the approach would have the advantage of pushing the burden of demonstrating the potential effects of the merger onto the parties who are most knowledgeable. Now, I had started saying that this is probably not my preferred approach. And the reason is that I have a nagging concern, okay? And my nagging concern is that I don't know whether it will have such a disincentive effect on large firm acquisitions that some beneficial mergers would simply not take place. So what if, for example, and it's all hypothetical, what if, for example, left alone, a nascent firm or a nascent technology that would have been acquired would die off? So what if without the acquisition, the nascent firm or the technology would die off? Or perhaps the large digital firm's know-how or investment input is needed for the nascent technology to reach its full potential. Maybe it won't die off, but wouldn't be able to reach its full potential. So for instance, maybe if YouTube had not been bought by Google, it wouldn't have died off, but maybe it would not have reached the potential that it has reached. In any case, this approach would require legislative action. A more modest approach that I actually prefer would be to develop a robust potential competition theory that would permit a more forward-looking analysis of effects in the merger review. Okay. So the problem with this is that current case law on potential competition doctrine is so restrictive and the evidentiary standards are so high that the doctrine is generally acknowledged by all to be of no use or little use in merger enforcement. But, and there's a but there, but the court's extremely narrow interpretation of the doctrine came over 4 decades ago in 1974. So it was a different world then, it was a different economy, the markets were different. So a lot has changed in the economy in the 40 to 50 years, actually almost 50 years since then. And today, the loss of potential competition is a genuine risk in digital markets. And maybe the time has come to seek major judicial relaxation of the doctrine to make it useful, or maybe just overrule it completely. I think the thing is that technology markets today are so fluid that if you were to apply the standard approach, I'm coming to an end. If you think that my time is almost, I'm coming to the end, that the standard approach to evaluate whether a merger may reduce competition is likely, it doesn't work very well. It's probably going to result in under-enforcement if we apply the standard approach. A potential competition theory would help us identify a potential comparative force farther out into the future, and that would be useful. I'll just make one other point, and that is Jason Furman, who is, I believe he's an economist, well known, in a 2019 report for the UK competition authorities, has recommended a potential competition test that would consider the likelihood of harm and the scale of harm. The idea is that if the scale of harm, if it were to occur, was very, very large, then we would tolerate a smaller likelihood of harm, and we will err on the side of barring a merger in that case. So that seems to be a rather balanced method of treating potential competition. Our Supreme Court precedent, as I said earlier, on potential competition wouldn't permit this treatment. But as I said earlier, markets and our economy have changed a lot in the 4 to 5 decades since the Supreme Court last spoke on the issue. I don't think we can just assume that stare decisis would preclude change. And perhaps, and that's my hope, that the agencies will be willing to bring a test case on the issue and maybe get it resolved. So thank you.
Larry, we can't hear you. Not yet. Still can't hear you.
How about now? Is this better? Great. I'm sorry about that. We're living in 2021. So of course there has to be an audio issue. So anybody playing Zoom bingo can check that one off your list now. Professor Lau, thank you. That gave us a lot to think about. DOJ and FTC have both, I think, some would say, started bringing a few nascent competition cases out there, but I don't want to put the cart before the horse. I want to give Professor Alford the chance to tell us what he thinks. I have a funny feeling he shares some of your views, and he might have a few slight tweaks. So let me introduce Professor Alford. Professor Roger Alford is a professor of law at Notre Dame Law School. He served as the Deputy Assistant Attorney General for International Affairs with the Antitrust Division at the U.S. Department of Justice from 2017 to 2019, where much of his focus was on big tech concentration and market power. And I had the good fortune to work with Professor Alford while he was at DOJ. Professor Alford has been published widely on both antitrust and international arbitration. And he is currently consulting with the Texas Attorney General's Office on the case Texas v. Google, which alleges anti-competitive advertising practices. Professor Alford, the floor is yours.
Thank you. Can you hear me okay? Great. So Colby, can you take down the share screen just for a minute so I can do just a few quick introductory remarks and then people can see me. So first of all, thank you, Emory Law School and Emory Law Journal for the chance to do this. I'm thrilled to be able to be with you and to join you for this wonderful discussion. And I look forward to the Q&A and for the opportunity to put something together for the Emory Law Journal as well. And as Larry said, Larry just did an absolutely fantastic job at the DOJ when I was there for 2 years, from the summer of 2017 to the summer of 2019. Larry was just really an incredible worker in the front office, and I could go on and use all my time about how great Larry was in terms of his efforts at the DOJ. So Colby, you can put that up now. I'm going to talk about what I'm calling "You Can Be Here," the bipartisan consensus on big tech. You know, it's interesting, with the change in administration, there are many areas where there's, you know, dramatic differences of opinion about a whole range of different issues. But it's interesting because antitrust law, quite often, there's a so-called bipartisan consensus that often occurs in the world of antitrust. Obviously not on everything, but on a lot of the core things. And the funny thing is that bipartisan consensus traditionally had been fairly conservative about enforcing antitrust laws and probably erred on the side of under enforcement. Whereas now we're moving in the direction, I think, of an agreement, a bipartisan consensus that there has been under enforcement and that we should be more aggressive and more assertive. And so now there is, I think, a bipartisan consensus for more work to be done, more efforts, more cases. And so that's what I want to talk about today is that you can be here, the bipartisan consensus on big tech. So if you want to, Colby, send the next slide. So the launching point for my discussion, this is probably familiar to many of you in the audience. This was circulated widely on the internet during the Black Lives Matter protests in the summer. And I thought this was a useful Venn diagram to think about, you know, that there can be at the same time what may appear to be positions that are in tension with one another, but they may in fact are not. And so there can be at the same time outrage at the death of George Floyd. There can be at the same time concern about structural reforms that are necessary in the police system. There can also be at the same time a strong defense to the legitimacy of peaceful protests, and also at the same time very strong support for the prosecution of looters and rioters. And so this is, I think, an interesting Venn diagram where you can be here in the middle with all of those positions. And I want to the next slide, I want to say something similar about antitrust, which is you can take positions that might seem somewhat in tension with one another, but in fact are not. You can embrace the notion that big tech provides valuable services. You can also at the same time embrace the notion that big tech is too powerful. You can also embrace the notion that current antitrust laws are inadequate to the current tasks that we have before us. And then you can also at the same time also embrace the notion that big tech is violating existing antitrust laws currently. And so that's what I want to talk about today. And I want to suggest that you can be here in the middle, embracing all of those propositions and do it in a bipartisan way. That there is, I think, an agreement across the political spectrum that all four of those propositions are true. So let me start on the next slide with the first one, which is, I think, the self-evident point, right? Big tech provides valuable services. It's an interesting thing that we all, I think we all probably in the audience use all of these products, right? In one way or another. We all recognize the value of Amazon and the efficiencies of Amazon. Many of us have Apple products. Some of us are very, very loyal to those products and recognize their benefits. Facebook or Instagram or similar social media services are also quite popular and incredibly common for people to have accounts like that. And obviously you can't really avoid using Google in some fashion or another, whether it be Gmail or Google Search or Google Calendar or things like that. So they all are very, very valuable services, and you could go on and talk about others, Twitter, Netflix, a whole variety of different types of so-called FANG products. And I just put a few points there that are obvious, but big tech connects people in very valuable ways. We are able to remain in contact with people that we wouldn't otherwise do so, and that frequently happens in ways that were just simply not possible in previous decades. Obviously, big tech provides incredibly ready access to information. We have a massive computer in our pockets, and we have incredible value associated with that. Big tech develops platforms for businesses. It's not only that these are businesses in and of themselves, but these platforms can leverage the goods and services of small businesses. And you can think of a whole variety of different examples of small businesses and other types of entities that have basically built their businesses on these platforms. And then, of course, these big tech accelerates economic development and globalization and progress in a whole variety of different ways. They are accelerators of economic progress and development. So we can all admit that and embrace that and not be shy about the fact that they're valuable services that they provide. But at the same time, you can also say that big tech is too powerful. And so, there's a whole variety of ways that they're too powerful. Not all of those are related to antitrust law, but there's many of them that are related to antitrust laws. And I think there is increasingly a widespread common consensus that big tech is simply too powerful right now. And that's true in a whole variety of different ways. They self-preference their products and services in ways that are anti-competitive. You know, obviously not every single self-preferencing behavior is anti-competitive, but they self-preference in ways that are their products and services that are problematic. They stifle competition in a whole variety of ways through control over their platform, by driving out direct competition, by dramatically discouraging new entrants. Venture capitalists just talk about kill zones where they simply do not want to fund new startups if they're going to be competing directly with big tech products. They use their broad discretion to censor voices on platforms. In the old days, a couple of years ago, we used to talk about the fact that big tech can deplatform someone. But we know from the past month that not only can big tech deplatform someone, they can also deplatform a platform, right? They're so powerful that these platforms can deplatform other platforms. And we all know about the censoring and the risks associated with the censoring. And totally separate from antitrust law, there is intense concern about, if you have ever seen the Netflix show on the social dilemma, the addiction and the sort of persuasion technology that they have put into place to encourage addiction and to basically feed off the addictions that all of us have with respect to big tech products. So in a whole variety of ways, this just is a tip of the iceberg. There is, I think, a bipartisan consensus that big tech is simply too powerful. There's also a third proposition that I think can be shared, and that is that both conservatives and progressives think that the current antitrust laws can be improved and that the current antitrust laws are inadequate in many ways. I think the House report that was issued in December is a landmark, over 450 pages with wide, broad sweeping recommendations about things that should be done to address big tech dominance and power. Among those, and passing new regulations to restore competition, strengthening current antitrust laws in a whole variety of different ways, including the way that Larry mentioned with new legislation by Senator Klobuchar, reviving antitrust enforcement. There was an increase in the funding for both the Federal Trade Commission and the DOJ that passed on a bipartisan consensus that we need to have more money to these enforcement agencies to be more aggressive in enforcement. And then on the progressive side, there is an appetite among many to reject the traditional consumer welfare standard in favor of a more jurisprudential approach that harkens back to, prior to the 1980s with the Chicago Revolution. And so I think there is some serious consideration among progressives that we need to rethink the entire consumer welfare standard. On the conservative side, the Republican side, there's also, I think, a recognition that the antitrust laws in many respects are inadequate. So Colby, if you want to go to the next slide. So there may not be agreement about everything with respect to the ways antitrust laws are inadequate, but I think there is common ground that, that there are ways to improve the current antitrust laws. Among them, traditionally, consumer welfare standard is focused on price controls and issues related to price, but there increasingly, even among conservatives, is a recognition that consumer welfare standard needs to be more broadly defined to include quality metrics, and those quality metrics may be things like privacy. So they probably would not embrace the idea, most conservatives, of eschewing the consumer welfare standard, but they would be open, quite open, I think, to having enhanced understanding of what the consumer welfare standard entails. So that would be an example, I think, of an improvement. I think there's also an appetite for new regulations, a variety of different types of new regulations. I think House Minority Leader Buck, in his third way response to the House report, talked about passing new regulation to address data portability and operability, just like you can keep your cell phone number, but change carriers from AT&T to Verizon. why can't you do something similar with all of your data? Why is it that everything that you've uploaded in one particular platform stays there and cannot easily be moved to another platform? Is it possible to allow for greater data portability and interoperability? There's also, I think, a strong openness among conservatives to rethink indirect purchasers, the rule with respect to Illinois brick, and whether or not that should be reconsidered. I think one of the final speeches that Assistant Attorney General Makin Delrahim gave in the waning days of his time at the DOJ was to basically encourage the repeal of Illinois brick. And I think that was something that would be on common ground with progressives. He also mentioned the possibility that there should be greater clarification, probably statutory clarification on American Express. And so exactly the scope and the breadth of the American Express doctrine with respect to two-sided platforms. And then interestingly, also, I think there's bipartisan consensus on some type of shifting of the burden of proof in merger cases. So actually the possibility of some sort of burden shifting if the market share, I think Makin Delrahim mentioned above 50%, that it might be that the burden should shift to not to the agency, but to the competing merging parties to prove that it is pro-competitive instead of the agencies being required to show that it is anti-competitive. So all of those, I think, are examples of a recognition. And I should also add that it seems that both progressives and conservatives are open to the idea of more regulation and even possibly creating a regulatory body to specifically deal with digital issues and big tech issues. So the third proposition, I think, is a bipartisan consensus that existing antitrust laws are, in fact, in need of an update. And then, of course, the final proposition, which we have recently seen with a whole spate of recent cases, is that big tech is currently violating existing antitrust laws. The DOJ, in a landmark case with 11 other states, sued Google in October, arguing that Google dominates the search market and the search advertising market, and it does so in a way that is an abuse of their monopoly power, and argued for the need to address that issue in a forceful way. I think, and since that time, I think another 3 states have also joined that lawsuit. So I think the DOJ versus Google case is a landmark case. It's probably the most significant case that has been filed since the Microsoft case to express concern about monopolistic practices. A coalition of states led by Colorado and Nebraska and a few others have gone further in that. It's a related case, but it's also arguing for even further. It's dealing with a whole variety of different so-called vertical aspects of the Google search monopoly, and they are going even more aggressive, so arguing that different aspects of Google should have structural relief with respect to their monopolistic practices, and they deal with other issues that are not addressed in the DOJ case, things like transportation and things like that. The Texas case, the Texas versus Google case, the one that I've been consulting on since August of 2019, focuses on anti-competitive practices in the ad tech market. The key focus there is that Google has a monopoly power across the ad tech market on the supply side for publishers and on the demand side for advertisers, as well as the exchange. They have monopoly power in those different segments of the market. And they also have monopoly power with respect to certain information data that they control and they use for purposes of targeted advertising. And on top of that, they also have monopoly power with respect to adjacent markets like YouTube, and they basically force advertisers to use Google products, Google advertising products, if they want to advertise on YouTube. So there is, in that case, an argument of both monopoly, abuse of monopoly power, abuse of attempted monopolization and monopoly maintenance, as well as tying arrangements in the Texas v. Google case. And then also the 2 companion cases that were filed on the same day, also in December of 2020, the Federal Trade Commission versus New York, and I think there may be a typo there, but Federal Trade Commission versus Facebook, and then New York versus Facebook. Both of those cases are arguing for essentially that the acquisitions, we just already talked about in the previous presentation, but that the acquisitions of WhatsApp and Instagram led to monopolization practices that are anti-competitive. And so both the Federal Trade Commission and the New York with, I think, over 45 states have sued Facebook. And obviously that is, just the start. There are lots and lots of rumors of other cases that are imminent, right? There's a private lawsuit already against Apple with respect to the App Store. There's lots of investigations of Amazon. There's rumors that either the DOJ or some states will also bring additional actions against Google. So I think there's a bipartisan consensus with respect to the fact that big tech is currently violating antitrust laws as they stand. And it's interesting how bipartisan a consensus is this. Every single state has joined one or more of these lawsuits, with one exception, the state of Alabama. And I don't think it's because they're not concerned about big tech, it's for other reasons that I won't go into. Every single state has joined one or more of these lawsuits. And I think that reflects a bipartisan consensus that big tech is violating antitrust laws as they currently exist. So let me stop there, and then we can open it up for other comments or questions from Larry.
Great, Roger. Thank you. That was helpful. The Venn diagrams always bring me back to the classroom, so I'm happy I got to feel like I was back in school again. Let me start the questions first by just reminding all the audience that if you have questions, please put them in the Q&A, and we'll try to get to a bunch of those in a few minutes. The first question I think both of you might have an opinion on, Professor Lau, I'll give you first crack at it. This kind of gets at some of the topics I think this symposium has handled before our panel. How should consumer privacy and data considerations play into the antitrust analysis generally, but especially when it comes to big tech, whether it's mergers or monopolization cases? Professor Lau?
Yes, Larry, that's a good question. I think privacy and data security are primarily consumer protection issues. And that they would they'd be good to be subject to consumer protection regulations. But I think that privacy is also a competition issue, especially in the merger context, because privacy protection is a dimension of quality competition, right? So in mergers involving firms that deal with a lot of consumer data, I think we should ask, and I don't think the agencies do enough of this, is that they should ask whether the merger tends to lessen competition relating to privacy. So because if it does, then it could lead to a degrading of privacy protection. So I think in the Facebook acquisition of WhatsApp, that's probably one thing that they could have considered, but probably did not do so. The theory of harm, the theory of comparative harm, would be that when rivals are too small and too weak to make a comparative difference, then the large digital firms will have no incentive, will have little incentive to compete on the basis of offering more privacy protection, especially when those protections would reduce their profits on the advertising side, right? Because if you have stronger privacy protection, then it's going to reduce their profits, because the more personal data that they collect and that is provided to the advertisers, the more the advertisers can target the advertising, and they will pay, and they'll be willing to pay higher rates. So when you have a stronger privacy protection, it generally comes back to hurt them in the sense of having slightly lower profits. Now, having said that, I think competition by and large is not a very effective way to encourage privacy protection. And so, because antitrust law isn't exactly well suited to address these concerns for a few reasons, or at least as antitrust law is practiced nowadays, okay? Privacy harms are very difficult to measure, right? Unlike price effects, they're hard to measure. And then exacerbating this difficulty is the fact that individuals have a wide range of privacy preferences in terms of privacy. So consumers have different trade-off points. Some are willing to trade some are willing to trade off more privacy for more free products and to get more quality improvement and more innovations. They're willing to trade more. And some people, especially younger people, may actually appreciate getting more targeted ads. They may actually find it useful, whereas a lot of people would not. So given that, it's really very difficult to aggregate and balance the harms and the benefits to all users to see if the net effect on privacy is negative, which is a step that has to be done in standard antitrust analysis. So there are a lot of difficulties in trying to tackle the problem on the antitrust front. But I think there's just widespread consensus, there's just consensus that we need to have stronger privacy protection. And we need to have perhaps a consumer protection oriented regulatory regime. I don't think, I could be wrong, but I don't think the FTC's current Consumer Protection Authority under the FTC Act is adequate. If it's not adequate, then it should be supplemented with additional legislative action. I think privacy protection, to go back to the point that Roger was making, seems to enjoy a fair amount of bipartisan support. And so I think passing a privacy and data security law shouldn't be impossible. Now, when you asked about data, were you talking about big data or were you talking about data security?
Big data.
Okay. I think big data is a very big data considerations are very important, should be very important in the antitrust analysis in markets that are heavily reliant on consumer data. And that's basically Google, Facebook, most of the tech giants. And that's because consumer data is an important input for effective competition. You can't really compete effectively if you are at a severe data disadvantage. At the same time, again, as Roger has said, we benefit a lot from large firms having consumer data. Data helps business make predictions. It helps them improve the services. It helps them cut costs. And for ad-supported platforms, having consumer data is needed to attract online advertisers, and that's their business model. We wouldn't have the emails and Google Maps and so forth, or Facebook for that matter, unless there is this model which allows them to monetize our data. And so it's important. But in that respect, consumer data can serve as a barrier to entry, because if you need the data to be able to compete, then the company that has a vast consumer data advantage would be entrenched. Their market power is going to be more durable, and it'll be very, very difficult for a newcomer to be able to come in and establish themselves, even if they may have the better product. It may make it difficult for a fringe firm to expand their services. So I think that when considering a proposed acquisition by a large digital firm, one of the factors that really should be looked at, and I don't think it's looked at sufficiently, is whether the merger will allow the merged firm to further increase its data advantage over the rival, furthering foreclosing entry into the market, even if they may not be in the exact same market. Right, so you can collect so much data that it enhances your power over multiple markets. So I think we should err on the side of blocking a merger that will increase the merged firm's data advantage, because the absence of competition is just not good for consumers in the long term, even though I will acknowledge, and most people acknowledge, that consumer data is very helpful and has been very, very beneficial to consumers. And firms, in fact, do use it to benefit consumers a lot. So I think I'll leave it at that.
So, Professor Lau, are you thinking about sort of the idea of vertical mergers as opposed to the horizontal mergers between competitors? Maybe, for instance, the Google Fitbit deal that recently happened, or are you thinking other sorts of deals?
Well, I'm actually thinking of product extension mergers as well. So they're not exactly vertical. In the old days, we will call them conglomerate mergers. But when you use the term conglomerate mergers, people think of like Whole Foods and Amazon. They may think of Amazon buying Federal Express, right? But actually product extension mergers are conglomerate mergers. So I'm thinking of that, where they're not exactly in an upstream-downstream relationship, and they're not exactly competitors because they're not at that moment in time rivals. Right?
Thank you. Professor Alford, would you like to take a crack at this one?
Yeah, I think the privacy issue is of increasing salience. I think there is a dramatic concern about privacy. And I think it's a host of different issues. So the big tech companies will say, well, privacy is not an issue because you can always opt out of any privacy concerns that you have. But if you actually have tried to do that, which I have, you have to go to like a detailed article that actually tells you like, here's how you actually opt out of all of your privacy. It's not remotely intuitive. And you know, anytime you get a question from a big tech company where it's either yes or learn more, you know that you're being manipulated by the big tech companies, because yes and learn more tells you that they're trying to make it as difficult as possible for you to say no, right? And when you say learn more, you have to go through multiple layers, not just secondary and tertiary levels, but multiple layers to actually opt out of Google's or Facebook's or others' attempts to follow everything that you're doing. And on top of that, even when you do try to opt out of everything, you cannot opt out of everything. They are still tracking your behavior, your locations. There's been recent studies by a Vanderbilt University computer science professor by the name of Douglas Schmidt that basically has issued a report for DCN about all of the different types of snooping that is going on. So it's extremely difficult to opt out of related to privacy concerns. I agree with Professor Lau that privacy is first and foremost a consumer protection concern, and we should have more vigorous enforcement with respect to consumer protections with respect to privacy, including deceptive trade practices by these companies with respect to their representations about privacy. I think that's very, very important. But I do also think that privacy is an antitrust issue. And I think that increasingly we're seeing situations where companies are using privacy as an excuse to advantage themselves. So when a company says, we're doing this for privacy concerns, ask yourself this question: are they doing this to other competitors, or are they also doing this to themselves? And overwhelmingly, when they say we care about privacy and this is the reason they're doing this, what they're really trying to do is to create a walled garden. And the walled garden basically makes it more difficult for competitors to have access to the information about their users, and less difficult for the walled garden, for the giant big tech platform to do that. And so I think they are using privacy as an excuse to advantage themselves. The other thing I would say about privacy is that I think increasingly there is this possibility that companies are coordinating with each other about privacy. Because why is privacy so important? Privacy is about money, right? Privacy is about money. The more information they have about you, the greater ability they can get a profile, a composite image of who you are, and they can use that image across the different platforms and products and services to create a giant composite, like a really, really comprehensive composite picture of who you are, and then sell that information to publishers and advertisers at a premium. So there's premium pricing that can happen for targeted advertising. Targeted advertising equals information gleaned from your behavior and that is worth a premium for the advertisers and publishers. And so I think that it is the case that these companies are colluding with one another. There is a collusion with respect to privacy to try to make privacy as minimal as possible. I think the Texas v. Google case calls it privacy fixing, right? Where there's essentially a coordination among companies to create a common standard on privacy. So I think it is definitely an antitrust issue.
So, Professor Alford, let me just ask, putting the collusion aspect aside, I find that to be an interesting thought of yours, but wouldn't it be actually an efficiency in the normal parlance of antitrust lingo for there to be more complete data, so that when I'm searching for items for my 8-week-old newborn, Google knows and will target things for my 8-week-old and not give me things for a teenager. So wouldn't having all that data in one place be more efficient than having it disaggregated across different markets?
Well, they're arguing that in many cases, but what happens is that it is consolidated within one company, and then the information is not available to competitors. For example, the elimination of third-party cookies means that publishers do not know information that they always have known in the past about their own subscribers, right? So their own subscribers, they themselves do not have the information that they used to have because Google is blocking third-party cookies. And so what happens is basically there already was information asymmetries, but there is just a massive change of information asymmetries. And then they can use that information as leverage to force you to use Google's products and services, right? So they will be arguing efficiencies. I mean, targeted advertising is efficient in the sense that it's better than watching a football game and every other commercial is a Ford F-150 pickup truck and you don't want to buy a Ford F-150 pickup truck. So there is a value to targeted advertising. There's no question about that. But it's the way that they use the privacy controls to advantage themselves over their competitors.
Thank you, Professor. Professor Lau, I found it interesting as you were talking through possibilities between statutory changes and common law changes to the antitrust laws, and it seemed like you favored common law changes, assuming they could happen. Of course, the issue with common law change is that it happens slowly. Professor Alford and I were both involved, for instance, in the AT&T Time Warner case, where we would argue that it didn't happen the way we wanted it to happen. There are calls for there to be antitrust investigations and antitrust changes today against big tech. You know, not in a decade, not in 20 years, but today. So to get there, can we rely upon common law change? Or is there an intermediary step here of perhaps regulatory change that can get us there? Or do we really need something like legislative change? I know Senator Klobuchar just introduced her bill today, so I won't ask you about the nuances of that bill. But what is the answer in this big tech situation?
Well, let me first of all say that it's not that I prefer common law change. It's just that I think Congress is I don't want to say dysfunctional, but Congress has been considering some version of Senator Klobuchar's bill how many times now? She's introduced similar bills every session, right? And I'm just not so sure that if we are having an overhaul of the antitrust laws, whether there'd be enough consensus to pass it, especially when right now, anyway, we have so many urgent issues facing the country. And it would seem to me that antitrust is probably not in the highest in priority. So it's almost as if I'm thinking that common law is almost like a second best, okay? It could be that there can be something in between. So some regulatory version. So let's say the agencies, to the extent that they can, if by the use of the guidelines, they can nudge it a little bit to a more pro-competitive, pro-plaintiff side. So I think what I was talking about, potential competition, okay? So if the guidelines, right now it has maybe one word in the guidelines about potential competition, if they can expand on it and have a section on potential competition, it might have some influence on the district court. And maybe the district court opinion would not be appealed, or whatever the case may be. So I'm almost like grasping at straws. I want things to change. I don't think that statutory change, at least not the kind of statutory change that would be involved, because it's quite detailed. If you look at Senator Klobuchar's recent bills, I haven't read today's bill, but if you read the previous bills, you'll see how she tries to tackle everything. And you have to give her credit for trying to tackle everything. But you end up with a bill that's really kind of weighed down, and people will have a problem with this section, and someone will have a problem with another section. At least I don't see it as something that I don't see it as very optimistic, the passage of a bill like that.
Well, the one thing I do want passed is it does call for $300 million more for the DOJ and the FTC, and
Yes.
pay raises for people in the government. So I can say I'm in favor of that part. Professor Alford, let me ask a sort of a tangent off that question. Do you think that the recent change in administration, recent changeover in Congress will lead to antitrust changes, whether it's executive orders or whether it's actual legislative resolutions?
Yes, I think there will be change. I think that there is, you might say, an internecine battle within the Democratic Party about the direction antitrust law should take. And I basically think that you could say that there's three camps within the Democratic Party with respect to the direction for antitrust. There is the sort of Elizabeth Warren camp, which is like fundamental skepticism about big tech in every respect. You know, her presidential campaign had billboards of break up big tech, and she deliberately placed those billboards in Silicon Valley, right? And so I think from her perspective and from the new Brandeis movement, there is like, we want radical reform, radical change. And then I think in the middle, I would say someone like Senator Klobuchar, where, you know, they want to stay within the mainstream of existing antitrust laws, but they want it to be strengthened, and they want it to be more aggressive enforcement, right? And then I think there is this third camp of the Democratic Party, and that is essentially, I would say, that the Obama antitrust enforcement model. And that was, you know, very traditional, very conservative, you know, not challenging Google in 2013 at the FTC when they had the chance to do so, allowing the airline mergers to go through in a very, very questionable way, extraordinarily cozy with Silicon Valley, like really, really tight relationship between Silicon Valley and the Democratic leadership under the Obama administration. So I think that's the third camp within the Democratic Party. And, you know, you hear some names floated for the Assistant Attorney General or for the chair of the FTC, and different names are in different camps, right? And I think it's safe to say that we will not have an Elizabeth Warren acolyte as the chair of the FTC or as the leader of the DOJ, but we probably will have one of them, I would guess, as a commissioner. And then I would imagine that we will also not have someone in the vein of an Obama Assistant Attorney General as the DOJ AG or as the FTC chair. I think someone closer to Amy Klobuchar's inclinations is what we're likely we'll see.
Thank you. We have a question from somebody who is not me, but I will read it. Is it possible, just in pragmatic terms, that we've missed the boat already for legislative change, that big tech has become so powerful that lobbying efforts will prevent any change in that regard?
They do have unbelievably powerful lobbying efforts. If you look at the metrics of who pays the most for lobbying, the big tech companies are almost always very, very high up there, right? And so there's massive lobbying efforts by big tech with respect to any sort of significant change. But I think that the mood has changed, right? The mood has changed dramatically, even from when I was at the DOJ in summer of 2017. And I think there's a very strong appetite for more serious enforcement against big tech. And the amazing thing is that is true whether you're Mike Lee, you know, or Elizabeth Warren, right? There's a widespread, broad sense that we need to be more serious about these issues. And so I don't think it's too late. I think it's too late for some markets and for some companies that have tried to compete with the big tech companies, but I think that it's not too late for the broad sweep and trajectory of where big tech is headed.
Thank you. I'm going to switch gears just a little bit, and Professor Lau, some people on this call might be antitrust lawyers, but I think a lot are not. Antitrust in the labor market has actually become a fairly large issue recently. Just in the past couple of months, DOJ has brought some of their first per se, meaning criminal cases against people for various labor practices, and the idea of no poach of employees has entered the mainstream legal debate. So let me ask, just getting away, speaking solely about antitrust and big tech, what role do you think that antitrust should play within the labor market? And this is relevant to big tech, of course, because there were huge Ninth Circuit cases back in the day about labor and big tech. So, Professor Lau, what do you think? Oops, sorry, still on mute.
I'm sorry, I forgot to unmute myself.
Thank you for making me feel better that I'm not the only one who's done it today.
So first of all, the criminal no-poach cases that you're talking about, I don't think they're controversial at all, in the sense that we've always held that the input market, if there's collusion in the input market, it is a per se violation. So where the employers actually conspire to fix the prices for which they will pay for labor, that's basically what they're doing, right? It's a monopoly market. So I don't think that's a problem. I think what has happened in the past is that the government had not focused on that, and so they were not on the lookout for those things. I think it was the Silicon case that was one of the first ones to be brought, right? The Silicon case where you had Apple, Google, etc., where the companies conspired to not poach each other's employees. But really what I'm interested in is I'm interested in the labor exemption, which I don't think a lot of attention has been paid to. So as you know, we have an antitrust exemption for labor. That's Section 6 of the Clayton Act. And the exemption was passed in response to Congress's displeasure with how the Sherman Act in the early days were used aggressively against labor unions. So this exemption effectively allowed workers to engage in collective activities to perhaps promote their own economic interests. So that section starts out with this very strong declaration that says the labor of human labor is not a commodity. And then it goes on to say that they will not be subject to the Sherman Act. So the law itself does not use the word employee. So the statute effectively immunizes from the Sherman Act joint activities of workers. Okay. Now, the problem is that this exemption became tied to the Norris-LaGuardia Act, which is a labor statute, and the federal labor regime. And because it became bound to this Norris-LaGuardia statute and the labor laws, the boundaries and the constraints of the labor laws became superimposed onto the labor exemption, so that now, effectively, the exemption only applies to the union activities of employees. Okay, so it applies to a bona fide labor union negotiating for the employees. And in the old days, it was probably all right because most people were employees, right? They were in a formal employment relationship. And the percentage of people who are in unions was relatively high. But now one of the problems is that the American workforce is changing. And the segment of the workforce is made up of independent contractors, not in formal employment relationships is growing. The best example of that would be the Uber drivers. But that's just because that's a category that most of us know about. In fact, many truck drivers are supposedly owner-operators. That is, they own their trucks and then they're paid by each load. Okay, so they're considered independent contractors / owner-operators. And they are not covered by this exemption. So there are cases where these Uber drivers or these truck drivers would join a union, not a labor union as such, but join some sort of organization to bargain, to agree among themselves. And they are subject to the antitrust laws. So I argue that the exemption to fulfill its original purpose, its original promise that human labor will not be treated as a regular commodity to which the Sherman Act would apply. At the very least, the exemption should be amended to extend to concerted action by independent contractors as well. Now, you might say, well, maybe these independent contractors are misclassified, and if we make sure that they're not misclassified, then all problems would be solved. But the problem is that employers have a lot of flexibility in creating conditions, work conditions, and they can create the work conditions in such a way that's that's easier for them to defeat the claim that I am an employee. So if they if they make the relationship such that you have a lot of control, then it'll be more difficult to argue that you are an employee. So I think that if we extend the exemption at the very least to independent contractors, it's going to serve both the core purposes of the Sherman Act, and it would also serve the purpose of the original labor exemption. I think it will serve the original purpose of the Sherman Act because the Sherman Act was originally designed to correct problems with cartels, that we want to make sure that concentration of economic power is dealt with. I don't think at the time that the Sherman Act was passed that the fear of workers getting together to try to improve their circumstances was the driving force of the Sherman Act. And if you look at the legislative history of the labor exemption, the labor exemption was enacted during the time when most people usually fell into one of two categories. Either they were traditional employees where they serve one employer, and that single employer will control all aspects of their work life. So because of that, they were at a power disadvantage, and so the law protected them. But you were either that or you were an independent business person who competed with competing independent business people for the opportunity to sell goods or services to buyers. So in that case, it may make sense to exempt, to say that the exemption would not extend to them. So I hope, I guess this goes back to the question that you had asked me. In an earlier article, I had argued that we could read the exemption in such a way that will extend to independent contractors. But even at the time that I was writing my article, I wasn't convinced that you could interpret the section that way because there was just too much case law. Okay, and so failing that, I think we need to at least revise the exemption to give the exemption to let it cover the independent contractors.
Thank you, Professor Lau. As Professor Alford knows, I spent a lot of time a couple years ago getting 850 perpetual antitrust decrees thrown out in 79 districts across the country, and some of them related to labor. For instance, Eugene Debs, who's been dead for 100 years, the labor agitator, was still under a perpetual antitrust decree until about 2018. So it was labor was in my world recently. Professor Alford, we have a question from the floor that goes back to data and its role in antitrust. The question is, to the extent that one's personal data can be sold as a product, wouldn't a walled garden approach be preferable to an open market where data may be sold beyond recovery and used for nefarious purposes by more than just a single company?
Well, I think the answer to that is no. I think that you have to distinguish between what kind of data you're referring to, right? So is it first-party data that is in the control and creation of the big tech company, or is it your own personal data that's highly sensitive data, or is it something in between where it's data of a publisher about you, and then only the big tech company has access to that information, right? So I think you have to really distinguish between the different types of data and whether or not it's first-party data or third-party data. I think if you have a walled garden where only Google has access to the composite picture of all of the different types of information available to you, then what that means is that there is essentially a monopoly position with respect to information, and there is not the possibility of adequate competition with respect to that data. And that means that there will be essentially one market participant that has the information, and everyone has to go to that participant to get that information. And then Google can use that monopoly power to force you to buy a whole range of other types of Google products. So there's a tying arrangement that can happen when there is that sort of information. The other thing that I think is worth mentioning, and I think the national security experts are really concerned about that, is there's a single point of failure, right? Where essentially if all of the information is gathered in one location, all you need to do is go to one place to access that information. And so, for example, everyone thought that WhatsApp was encrypted end to end until they found out that Google actually has WhatsApp texts on their drives, right? And so all you got to do is access Google's drives to get WhatsApp end-to-end encryption because of an agreement between Facebook and Google. And so there is this potential of a single point of failure with respect to sensitive information that wasn't, I think, fully appreciated. So obviously the big tech companies will say the opposite. They're saying that we're promoting and enhancing privacy by basically limiting the number of individuals or companies that have access to that information. But I think that there are, massive competition consequences to that sort of argument.
So if I could just jump in and say something, I think maybe this is that would be one good reason to have a central regulator, right? I have some concerns about having a central regulator as well. But if you have a central regulator will be able to take a holistic view of the thing. So perhaps you could have interoperability, right? And of course, there will be some privacy issues involved. But if you have a regulator, perhaps they will ensure that there are enough privacy regulation. I don't know whether interoperability would work, and I don't think that the FTC or the Antitrust Division has the expertise to do that. But if you have a sectoral regulator, they might be better informed and might be able to regulate in that regard. And also then they will also be able to make sure that the privacy laws do not have the unintended benefit, unintended consequence of depressing competition, as apparently the rule, I forget what the European rule is called, the law, right? The law was intended to give an advantage to the small firms. So supposedly it now has perhaps an effect that was unintended, and is working against the small firms, because the small firms do not have the wherewithal to comply with it as well as the large firms do. So if you have a sectoral regulator, they'll be able to take into account everything and probably come up with a regulatory regime that will be balanced and that will protect as best they can consumers' interests.
Yeah, I mean, I'm actually curious about regulation as well. What I'm not sure about is the risk of a new regulatory body, right? I mean, it's one thing to say that we need new regulation. It's a whole nother thing to say we need a new regulatory body. My inclination would be to try to find a home for that new regulation within an existing agency. Probably it would be the Federal Trade Commission. That seems like the most logical place for it. But I would be a little bit reluctant to just have yet another new agency created for the sole purpose of dealing with digital regulation. I think it makes more sense to basically, if you're going to have new regulation, try to find an existing agency to deal with that issue.
I think I agree with you. I think that it could be housed under the FTC, but it would probably need additional regulation, additional legislation to give them more power than they currently have. And the good thing about housing it under the FTC is that they do have a dual mission, antitrust mission and consumer protection issue. mission. And they also have the expertise, right? They have economists who are well-versed in competition law, as well as being well-versed in consumer protection. So it might be a logical thing, but.
That leads me to one other question. You mentioned the EU, Professor Lau, and Professor Alford, you are an international law expert in addition to your scholarship in antitrust. And I just wanted to get your perspective on what lessons you think we might be able to learn from other countries and how they handle big tech, whether it's in merger or in the monopolization sense. Because given that many of these big tech companies are based in the United States, but have a larger reach around the world, maybe there are some international solutions here.
Yeah, in some respects, I think that's true. I mean, we all know the reality that other enforcement agencies were earlier than we were in enforcing the laws against these big tech companies. We had our chance in 2013 with the Federal Trade Commission in Google, and that, for whatever reason, did not move forward. But I think that we can definitely learn. We were skeptical, I think, in the United States about a lot of what Europeans were doing. And then the more we heard and the more we discovered, I think there was an acceptance of the fact that the Europeans were ahead of us on this. And I think it's interesting to note that even though the United States agencies were not pursuing these big tech companies at the same time that the Europeans were, there was a noticeable absence of criticism about what those agencies were doing. And so I will say this also. I think that with big tech companies, because of they're overwhelmingly are American companies, I think we have to recognize the reality that it is necessary for the United States to step up and deal with these issues. I think it's very alarming that Google threatened to basically cut off Australia if Australia doesn't basically cower to Google's demands with respect to payment of publishers. You know, the fact that Google can literally say to a country like Australia, we're going to just cut you off, should raise alarm bells, right? I also think the reality is that in Europe, the cases were incredibly significant, but the remedies in some of the cases, like the Android case, were not that great. And I think there is a political overlay to a European agency or an Australian agency ordering structural relief of the kind that a U.S. agency might be willing to do. So I think that U.S. agencies, U.S. enforcement authorities are more likely to demand American companies to be broken up than would another counterpart. And then the last thing I would say is, the cautionary tale about China. I mean, we got to be nervous about what is going on in China with respect to Alibaba and the use of antitrust laws for essentially the imposition of political pressure on dissenting voices, right? I think that is a cause for great concern. And as you know, Larry, we worked on this project for a multilateral agency procedures about due process, and you should only use antitrust laws to deal with antitrust concerns. I do think that there's a real risk in some agencies that they're using the antitrust laws for other purposes. So that's some of the things I would say.
Thank you, Professor Alford. Professor Lau, I don't know if you have anything to add on this topic. We're staying on mute, so I think the answer is no. And I'm looking at my clock here, and we are at the end of a very long day. So I think I really wish we were going and doing a networking and happy hour event out in Bacardi Plaza and everybody could get together, but I don't think that is in the cards this year. So
your mother is giving you a shout out.
Hey, look at that. Hey, Mom. Hi. I'll try to get the granddaughters down. We'll do a Zoom after this. Thanks, Mom. Let me just thank everybody for participating. I know it's been a long day, but we've really enjoyed this panel. And big thank you to Professor Alford and Professor Lau and Colby Moore and the entire staff. So with that, Colby, I'm going to kick it back to you for any closing remarks.
Yeah, I just have one more logistical note. I have gotten a few questions about how CLE will work. If you provided your Georgia CLE number when you registered, we are going to send that to the state bar, and the state bar will bill you directly for the CLE. If you provided an out-of-state CLE number, then we will send you a letter that you can then submit to your state bar that you can take care of with them. But outside of that, I just want to thank you all. I want to thank all the panelists, all the moderators today, the Emory Law staff, Amy, Rhonda that are here in the room with us, Sam, the dean, really everyone. This was a team effort. And definitely the first time we've ever done something of this nature. I thought it went really well. I know everyone probably has a little bit of Zoom fatigue right now, but we appreciate everyone sticking around to 4:30. And I think with that, we'll close.